Hello, everyone, and welcome to another episode in my ongoing series of interviews with UDRP service providers. My name is Doug Isenberg. I am a domain name attorney and founder of the GigaLaw firm, and I also serve as a domain name panelist at a number of providers, including at the Czech Arbitration Court, whose Secretary General is with me today. The Czech Arbitration Court, or CAC, is one of 6 ICANN-approved providers for the UDRP, the Uniform Domain Name Dispute Resolution Policy. The CAC was actually established all the way back in 1949, of course, long before the first domain name was even registered, let alone the rise of cyber squatting and domain name disputes that are obviously quite common today. As one of the oldest arbitration centers in Europe, the CAC, which is based in Prague, is attached to the Czech Chamber of Commerce and Czech Agrarian Chamber, and has handled a variety of domestic and international commercial disputes. The CAC began providing domain name services in 2005, when it started offering dispute services for the European Union's .eu top-level domain, and it was approved by ICANN as a UDRP provider in 2008. The CAC also provides dispute services for the Czech.cz top-level domain. Like almost all of the UDRP service providers, the Czech Arbitration Court saw a record number of cases in 2020, something I will be discussing with my guest today. And with that, let me introduce my guest, Lenka Náhlovská. As I said before, Lenka is the CAC's Secretary General, and she previously served as head of domain name dispute resolution. So she is quite familiar with domain name disputes in general, as well as the CAC's services in particular. So Lenka, thank you for spending some time with me today. And maybe we can begin with you just telling us a bit more about the Czech Arbitration Court and your role within it.
Thank you, Doug, very much for having me. I will be happy to discuss anything regarding the domain name disputes resolution here. As you said, Czech Arbitration Court has a very long name, but we use the abbreviation, the Czech Arbitration Court, or CAC, because it would be very confusing to use the whole name. We are a very old arbitration institution, and the main service we provide is arbitration. Over the years, we had a large number of cases. Last 20 years, we had over 27,000 arbitrations, both international and domestic. And maybe because of the international field of the arbitrations, we also moved to another ADR, because arbitration and other alternative dispute resolution systems are very similar in the main idea, which is to provide an alternative for commonly very expensive and very long common core proceedings, which are in Czech Republic sometimes really prolonged to several years, maybe 10 years. So it may be quite demanding if you want to reach a decision. And the same is valid for domain name dispute resolution. And that is why maybe we launched the .cz domain name dispute resolution. Actually, and I had new information about this. We launched first time we settled cases in .cz domain name dispute resolution. It was through arbitration, actually. So it was not classical ADR as we know it from UDRP or .eu, for example, but it was arbitration where the arbitrator was able to have cost or other arbitration fee for the successful party, or it was arbiter award which was issued during the process. There was possibility to hold oral hearing, for example. So it was a completely different system. But in 2015, we moved to alternative dispute resolution as we know it from UDRP or .eu because it has so many advantages, and also because Czech common courts did not like the idea of arbitration for domain name dispute resolution. So that is the absolute start of our engagement with domain names. As you said,
I often describe the UDRP when I talk with clients about it as a arbitration-like process. What you're making is a fine but important distinction between sort of domain name disputes, domain name dispute policies, and true arbitration. And of course, one of the reasons why the UDRP itself was created is because it's a much more efficient, much quicker, much less expensive alternative to not only litigation, but I guess to traditional arbitration as well, which sometimes is not even practical for something like domain name disputes.
Exactly. So that was, I believe, the main idea. Then, as you said, we launched our platform for .eu, domain name dispute resolution, in 2006. We were licensed back in 2005. And since then, we were a long time the only provider for .eu domain name dispute resolution. In 2017, WIPO became the second provider. So now there are two providers for the European Union top-level domain name. The proceedings in .eu is very similar to UDRP as we know it, but it has some distinctions. For example, we run the proceeding in all 27 official languages in European Union, or 24 official languages. We have 27 member states and 24 official languages. Another difference is for the three-part test, which is in UDRP. In EU, it's slightly different. I will not explain the details, but it's a little different. And we were starting the domain name dispute resolution with .eu. But in 2009, as you said, we were approved by ICANN in 2008, and in 2009 we launched our UDRP platform. And we started with very small numbers of cases, but as you said, the UDRP caseload now is at its top. It's we have record number as well as WIPO or the forum. So the caseload with us is very very progressive, and we have a big caseload.
So that makes me think of a couple of questions.
Yeah, sure.
I'll try to remember both of them as we go through. But my first is, so sort of with this historical perspective of handling .eu disputes, which is something, as you said, the Czech Arbitration Court still handles. It's my understanding, however, there just really are not that many .eu disputes occurring in any particular year. Is that correct? And has there been a decrease, or has it just never been subject to a lot of complaints?
Well, at the beginning of .eu, there were a lot of complaints because there was something like sunrise period in generic domain names, and we also handled such type of disputes at the beginning of the process of registering .eu disputes. So at the beginning we had over 700 cases a year, but now the number of cases decreased, and we have about 50 to 70 cases a year regarding .eu domain name dispute resolution.
And so why is that, aside from the fact that it's a bit more settled at this point, you don't have the same sunrise issues? Is it a reflection of the popularity of the .eu top-level domain in general? That is, my understanding is, like .com is certainly far and away the most popular top-level domain for registrations, so therefore it's the most popular top-level domain for disputes. Are there other reasons why there aren't that many EU disputes these days?
Well, I believe the biggest reason may be that EU domain names have strict eligibility criteria for registering the domain names. So only citizens or entities based within EU or another member states citizens are allowed to register .eu domain name. And that's something completely different from .com or .org domain name, which can be registered by anyone.
Right, unrestricted. So therefore, popular in general and also popular among cyber squatters. The other question that I had as you were talking just a moment ago about this sort of significant increase in the number of UDRP cases, which you said is something that WIPO and the forum and essentially all of the providers have seen since, well, in recent years, but it seems especially since the beginning of the pandemic in the spring of 2020. And I know the Czech Arbitration Court, as I said at the outset, had a record number of cases filed last year. Has there been, what is the reason for that, and how much of it can you attribute and why to the pandemic?
Well, that is a very interesting question. I believe that the online space was on its rise and it was very popular even before the pandemic. But during the pandemic, I don't know what it was in US States like, but here we had closed shops and every shop had to go online just to keep providing its services and goods. And I believe that the online space just raised very rapidly during the pandemic. And that's the situation where a lot of domain names were registered, and a lot of companies, I believe, started to want to have their domain name registered. Even they had trademark, but they didn't have a domain name. And now they found out that that domain name is not available because somebody else is using it. And I believe that the cyber squatting activities were on the rise even before the pandemic. But I found big increase in Czech Arbitration Court's decisions regarding some cyber criminal activity like phishing. And that arose with the pandemic rapidly, I believe.
And it's still going on today. At least that's what I see with my clients. Probably phishing is the number one type of cyber squatting related activity that I see.
Yes, and it's very dangerous activity because as I see in the industries that are filing most UDRP complaints, it's usually financial and banking sector, and there the phishing might be crucial for the companies and for the trademark owners, and they need some quick resolution of such domain name registration because it might help to prevent their clients from frauds and etc. So I believe that's one of the reasons. And also we had a few COVID cases, we call it COVID cases, where usually pharmaceutical companies are their trademark name is registered with some additional, for example, COVID vaccine or COVID-19, etc. And that was also something we saw in recent year in domain names.
Yeah, cyber squatters are certainly opportunistic, whether it's the pandemic or any other trend that we've seen over the last 25 years. So I'm also curious sort of how you and your team at the CAC operated during the pandemic. You've mentioned WIPO and the Forum, which are the two largest providers, but obviously the Czech Arbitration Court has a significant caseload as well. Maybe for those who aren't familiar with the Czech Arbitration Court's operations, obviously we've given some background on how long you've been doing this and where you're located in Prague, but can you give us a little bit of insight into inside operations of how cases are managed in general, and maybe how you're operating these days and have been since the beginning of the pandemic?
Of course. We have a center for domain name disputes here at the CAC. It's one part of the whole group, and the rest of CAC handles classical arbitration. Here at our center, we have two main case admins, me as the supervisor, and also additional personnel to help us to run the proceedings smoothly and quickly. We are in the Central European time zone, so there is a big difference between, for example, United States and Central Europe. So we have official hours in Central European time, and during those official hours, we are able to correspond with email and with telephone. If anybody writes an email to us, we are trying to respond within 24 hours, if possible. And during the pandemic, we went online as everybody did, but in case of domain name dispute resolution, it was super easy.
It was an online process already, even before the pandemic, right?
Exactly. So unless in opposed to the arbitration, it was a very easy job for us to start working from home. We did, of course, we had some basic work with it, because our employees had to get their computers and their other electronics. But apart from this, it was a very easy process, and we continued to work on the cases. I believe that the only problem which arose was with written notice sent by post or by some written mean to the respondent in the UDRP proceedings, because, for example, Czech post office and a lot of other post offices in all states refused to accept letters because of the pandemic. So we were not able to send letters to several countries, and we had to somehow get the actual notice of the respondent about the complaint by only electronical means or by telephone if available. But that was, I believe, the only complication we had, and we dealt with it. It was not a problem after all. But
well, yes, it's been interesting times for all of us, but the UDRP is obviously, as we've said, well suited, because it is a dispute process that takes place entirely online. So as I talk about a lot, the UDRP is a policy that all of the ICANN approved UDRP service providers apply and implement. There's the policy itself, there are the rules, but then the Czech Arbitration Court, like all of the UDRP service providers, has its own set of supplemental rules. And I know one way or one issue that the CAC's supplemental rules differ a bit from the other providers is with respect to fees. And I know in general, the CAC's fees are lower, but there's also a little bit of complication there that I know sometimes needs to be explained. So maybe could we talk about that for just a minute? Could you explain the fee structure for filing a complaint, a UDRP complaint at the Czech Arbitration Court?
Yes, of course. We have something called initial fee, which is basic fee is 800 euros. And it's only for simple
which is
cases.
About what, I think $935 US or somewhere about that.
Yeah, somewhere about that. And this fee is applicable for the proceeding where there is no response from the respondent filed, or if the case is not found to be complex by the panel. The panel may upon reviewing all the documents and the complaint, find that the case is complex and that it needs more time and also more resources to conclude into the decision. So in that cases, we have additional fee of 300 euros. So we get into the 1,100 euros for the UDRP proceeding. And that is, that is the...
So how often does that additional fee arise for a complex case?
Yeah, it's 5% or less. It's not very common.
Okay, so very, very uncommon. And there's another fee as well that is, as I understand it, maybe I'm stating this incorrectly, so please correct me, sort of optional, but that's a fee that a complainant, a trademark owner can pay for administrative, sort of an administrative compliance check. Is that right? And can you explain that, how that works?
Yeah, there is something called preliminary control, and it usually serves for the new complainants or new authorized representatives, because there are some issues that have to be formally correct in the UDRP. For example, the mutual jurisdiction, which is something I found that a lot of complainants or authorized representatives are not familiar with, etc. And if they pay this extra fee, we revise the complaint before initiation, before paying the fee and starting the UDRP proceedings, if the complaint really is administratively compliant. And then, of course, if they file, we have to request the registrar for the information about respondent and the who is information, which is in this time usually somehow masked or data redacted because of and you had your case study regarding the data redaction of who is information. So another control is only regarding this process, if the respondent is correct or we have to correct it. But that is basically the preliminary control.
Right, and I think you were referring a minute ago to the EU's GDPR, probably the General Data Protection Regulation, that has resulted since 2018, I suppose, in the redaction of a lot of domain name registrant information from the WHOIS database, in addition to the sort of pre-existing privacy and proxy services, which always complicates the UDRP process a bit for trademark owners filing complaints. Do you see a lot of redactions and privacy services in filings at the CAC?
Yes, a lot. I believe it's like 90% of the cases are redacted at first, and we have to contact the registrar and verify the data.
Right. So we were talking about fees at the Czech Arbitration Court in the supplemental rules. Are there other differences in the CAC's supplemental rules? Anything else you want to talk about that may differ from any of the other providers?
Where there are slight differences, but nothing that would be so exceptional, I believe, that needs to be somehow talked about.
Okay. So let me ask this question. Who is filing? Obviously, all the decisions are published on the CAC's website, just as they are on all the providers' websites. So anybody can go look up that information. But in general, who is filing complaints at the Czech Arbitration Court? Not necessarily particular names of trademark owners, but are these companies that are more likely to be based in or near your office in Prague or elsewhere in Europe, or in particular industries or for particular substantive issues? I'm just trying to understand how a trademark owner decides that the Czech Arbitration Court is the appropriate place to file a complaint.
Yes. Well, the nice thing about UDRP is that it doesn't know any borders. So we have, of course, filings from USA as well, for example, but mostly our complainants are European-based companies or companies that are based in the USA but have some affiliations to Europe. So I believe that the connection with Europe is clear. And as I talked about the industries before, financial sector and banking sector are big complainants before CAC, also pharmaceutical sector or online gaming, etc. There are a lot of complainants and trademark owners that are using our services, usually with some connection to Europe. That's probably also why they know us, because we are Europe-based and we have the biggest clientele here.
Right, right. And you have resources on your website that help explain the domain name dispute process for all of the policies that you administer, not only for the UDRP, but as we said, for .eu and .cz. But maybe talk a little bit about what some of those resources are. I know there's an important FAQ, frequently asked questions, that you provide for both complainants and respondents. I'm just curious, somebody who's looking to file or defend a complaint at the CAC, what sort of support and resources do you offer?
Yes, as you talked about the UDRP, we have the FAQ part of the platform, which will help you to get through the process. Also, the complaint form is very easy to fill in. We try it to be very simple, so you really have each section described what you should fill in, what are the 3-part rules for the UDRP, what is the test, and you have to fill in what rights do you have to your domain name, why there are no rights or legitimate interest of the respondent, and where do you see the bad faith. And I believe that helps, because a lot of complainants, when they are not familiar with the process, they forget maybe one of the tests. Maybe usually it's bad faith, as I see from the complaints filed. So I believe that helps. In .eu we also have overview of our decisions, because as I said, we have the longest history for .eu domain name dispute resolution. And in UDRP, there is the WIPO overview, which is complex, and WIPO had a lot bigger caseload. They had 50,000 disputes this year, I believe, and I don't know if we could add anything to that overview that would help our complainants, so they can find this information online. They can find all the decisions published, which I believe is also very helpful.
So when you say the WIPO overview is complex, I think you mean that as a compliment, not that it's complex and difficult to navigate, but that it's thorough and detailed and helpful. Is that correct?
Exactly. It was a compliment, maybe.
No, I just wanted to
by my not native.
No. Well, I only speak English, so I just want to make sure I understand what you're saying. And so I've had this conversation with you as well as with those at other of the UDRP service providers. So because the WIPO overview is something that WIPO has been publishing for a number of years, and as you say, addresses, many, if not most, of the issues that typically arise in UDRP proceedings. Do you consider it appropriate for parties to cite to the WIPO overview if they are filing or defending, responding to a complaint at the Czech Arbitration Court?
Yes, and certainly, and you can find the referring parties, or the panelists. Our panelists also refer to WIPO overview, and that's completely fine.
Okay, great. Well, what else, if anything, do you want complainants or potential complainants and domain name registrants who may be respondents to know about the domain name dispute system in general or about the Czech Arbitration Court's offerings in particular?
Well, we are trying to keep the proceeding very simple, very straightforward, and very quick. We have, in average, our UDRP proceeding takes 40 to 45 days. It's quick. It's very cheap because our fees are the lowest, and we try to be helpful during the process. So anytime you will write to us with some question, we will get back to you as soon as we can. That's, I think, our philosophy, to help the complainants and also to help the respondents if there is anything wrong with the process, anything they need to help with. We are trying to be here. And that's what we also like about the ADR, that it's not so formal, it's quick, and it has results. So,
are there specific or common mistakes that you see parties making when they're filing complaints or respondents? Any particular issues that you see regularly arise?
Yes, usually in UDRP, there is no additional filing. You can try to file something additionally, but the panel doesn't have to accept that. That's the first issue. And also you couldn't have the time for that because it's very quick. The process is very quick. So I think it's best to really put the effort into the initial complaint and try to have it as detailed and with as many evidence as possible, but also try to keep the evidence which is relevant to the case, because in some cases we had a long list of evidence, but only few of the documents were actually, referring to the case at issue. So keep it simple, but try it to be as detailed as possible for you to be successful.
Yeah, that's a very fine line to walk. I think that's a great point. As a panelist, I obviously see a lot of complaints and responses that are filed, and you make an excellent point. Some are too short, some are too long, and it's important to strike that right balance. And yes, for trademark owners filing a complaint, know that the complaint is intended to be the only document that you file in the course of a proceeding. Obviously, as you say, there are some exceptions, but all of those factual and legal arguments should go into the complaint. As I tell my clients, it's easy to file a complaint, but it's a lot harder to file a very good complaint. So it is something that takes some time and effort and experience. So that's interesting to hear you give that advice.
Yes, that's exactly right. You will have one opportunity, to amend your complaints when you have the whois record from the register. And also a lot of complainants don't use that opportunity to amend the complaint accordingly. So to use the information they gain, which is also, I believe it's good when you know the actual name of the respondent, to see who registered the domain name, to also use it in the complaint. But afterwards, they have no chance to say any additional arguments, to file any additional filings, and so the complaint is crucial for the complainant to be successful.
Right. Because amending a complaint once you have that updated whois information is not necessarily just a procedural issue. As you say, there may be some substantive issues if, for example, the newly disclosed underlying registrant is somebody who has been a respondent in previous UDRP proceedings. So yes, there can be something of substance to learn from that.
Yes, so, exactly.
Okay, well, great. Lenka, I think if nothing else, in addition to everything that we've talked about, it's great to know that there are people like you behind the scenes of the website of the Czech Arbitration Court and the services that you offer, and that you are there and that you respond by phone or by email, and that there are human beings, even though this is a relatively straightforward process, there are human beings like you and your team who are handling these. So it's nice to get a little peek behind the curtain, so to speak.
Yeah, thank you very much for the opportunity, to show us as human beings.
Great. Well, Lenka, thank you very much for being here today and for talking with us about the Czech Arbitration Court. Thank you.
Thank you, Doug.